All right, thanks everyone. I appreciate the opportunity for you guys to come in today and join us. I'm excited to have a group of panelists here. We have some people from the RCMP policy centers. So we have Emily. She is with the National Program Manager with Occupational Safety and Prevention. We have Salon Gagnon, who is the Director of Occupational Safety and Prevention. Salon. We have Kim, who's joining us. She's off video today, but she's the National Advisor for Medical Case Management Determination Process, i.e. you guys say you got hurt. Does the RCMP make a determination on if that was a work-related injury or not? So we'll touch base on that. That segues us over to Veterans Affairs, and we have Lynn up in my top left corner. She's the National Program Specialist with Veterans Affairs. And then Nick, who will be kind of the meat and potatoes of today's stuff here, he's going to be bringing us through what the benefits we have as RCMP officers are. And he's a benefits programs officer with VAC. So in saying that, I appreciate your time. I know a lot of you got this from the email that came in through our regional updates. Some of you follow me at Chris Voller at NPF. That's appreciated. Housekeeping, we're going to do questions and answers in the chat. We will pause kind of throughout to take questions and answers. And we have everyone muted to stop the what if person from slowing down because we do have a lot of course content. Not trying to stifle your ability to communicate, but this today is going to be more of a high level conversation, making sure we understand our access to it, how some of these processes work. And then in the chat, you can see there are some documents that Megan's already inserted that have a whole bunch of hyperlinks and reference materials that we have collated for your ease so that later you can take these breadcrumbs and look at, hey, this is what I was interested in, or hey, this is something else I want to learn about. Because frankly, like I had, I think, 8-10 years service before I found out that Veterans Affairs was something that RCMP officers were entitled to. Like prior to that, and my dad being an RCMP officer, I literally thought that this was only for the military. And to that point, like someone who had suffered double amputations, like I really had no idea that Veterans Affairs was for RCMP officers. And I don't want that. I want our generation of Mountie to understand what their entitlements are and the supports that are available to them. As far as that goes, we're going to keep the personal, individualized questions out about your specific file, not for this venue. I totally appreciate it. It's a great time with a captive audience with these specialists here, but we don't want to share your personal information in front of the couple hundred individuals who are online here, and bearing in mind that it's recorded, so we don't want to have a capturing of your information down the road. With that being said, I'm going to try and make this as member friendly as possible. So as we go through this, I'm going to take it from like I'm working at a police level to I get hurt to where does my determination process work? How do I use a 3414? Do I need a medical certificate? And that's the RCMP's point of view in the back half of it. We'll start with all of that, but then we're going to segue with Veterans Affairs. Do they use that information? When do they use that information? Do they need any of that information? And Nick's going to bring us through what that looks like and what we're entitled to, because the Canadian Armed Forces has different entitlements than we do. And they also come from a separate pool of money. Like, I think a lot of people don't understand that. And they're like, oh, like, I'm going to leave that for people who went to Afghanistan. And 100% respect people who went to Afghanistan. They need that support. But if you're making an RCMP application, you're not taking anything off the plate of that Afghan vet. Just a misnomer. Okay, so getting into it, I'd like to start with the 3414. So I'm a 17-year member. I'm a director. I've been a detachment commander, had the opportunity to work in different units. And I always really thought the Lab 1070, which up until, November 12th, that was the form we were using for a while. And now the 3414, what was old is new again, was the document that I needed to submit if I got hurt at work, and then for Veterans Affairs to reference that later. But Emily, in speaking with yourself, can you educate me a little bit more? Because now I understand that's not the case. And I think a lot of members think, I get hurt at work, I need to lay down that 3414.
Thanks, Chris. Yes, so I'm Anita Butt, National Program Manager. I've been with the RCMP for over 10 years with the Occupational Health and Safety branch. And there are a lot of misconceptions with the 3414. So I'm here really to give you a good overall understanding of why we have the 3414s, what the purpose of it is, and when is it required. So the first specific requirement under the code that we operate under, so we operate under the Canada Labor Code. We are federally regulated, and we report our activities in terms of occupational health and safety to the labor program, which enforces the Canada Labor Code. So much like the RCMP enforces the criminal code, the labor program enforces the Canada Labor Code. So we have requirements under the Canada Labor Code to report on specific kinds of hazardous occurrences, be it fatalities, disabling injuries, loss of consciousness due to toxic atmospheres or electric shock, for example, fires, explosions. And so we have a requirement to report it as soon as possible, some under 24 hours, some under 14 days. And the vehicle to report that is through the 3414, the Hazardous Occurrence Investigation Report. If we fail to report this information in time, or if we fail to investigate the hazardous occurrence to identify what caused it and what we need to put in place to prevent something similar from happening in the future, the labor program can actually enforce some interventions that can be a promise that we promise that we won't do it again. Here's what we're going to do to ensure that this doesn't happen again. Labor program can tell us thou shall through a written instruction. We can also face fines, or we can face prosecutions if we don't follow that process, report those incidents. Yes, go ahead, sorry.
So for that, like from the members' perspective, I think a lot of people were filling that out thinking, I got hurt and I want to record this injury, so this is why I want to. But really that 3414 is about the circumstance they got hurt in, right?
Yeah.
Like, is this an unexpected circumstance they found themselves in, and what can the employer do to mitigate that from having happened again?
That's correct. So it's an employer form to document not only the hazardous occurrence, the situation that led to the injury, or could have led to the injury, but it's also what the employer did about it, the direct causes up to that incident, and what the employer's done about it to ensure that it doesn't happen again. So it's really an employer form, and it's to document what went wrong and what do we do to prevent something like that from happening again. So it's less so about the injury and more so about our regulatory requirements to ensure the health and safety of employees while they are performing their duties under the RCMP's direction.
So if the member is injured, they will complete the Form 3414, but the purpose of it is to investigate the how and why they got injured, not really the documentation of the injury itself.
That's correct. And one thing that is not well understood is that the 3414 is not actually to be completed by the injured member. The responsibility for that injured member is to report it to their manager. And it's the responsibility of the manager to investigate the hazardous occurrence, to find the direct cause, what were the malfunctions in the operational system, and then document their findings and their actions stemming from that investigation to prevent a similar occurrence. Document that through the 3414.
But the member, to get that injury, also looked at and into kind of the determination process down the road, and down the road where it will be on their medical profile. So someone like Nick or Lynn may need to reference it. That's when they're going to want to look at the Form 6584, which is specifically related to the member being hurt, and not looking at the circumstance of it, but so much the validation of the injury itself, which comes with a certificate from a practitioner, et cetera. And I won't get into that quite yet because Kim's going to go through that. But the delineation there is, I think a lot of members were using a 3414 thinking, this injury, this is the form, VAC's going to need to capture that. Nick's going to get into how that's somewhat of a misnomer as well down the road. But I really want to clear this up because I think members, we've been doing that wrong. Like I've been doing that wrong. And now I just want to get into one circumstance, Emily, if I may. So, like those are some of those clearly defined ones. Like I get punched. Okay, I'm immediately hurt. I'm a gentle soul. I'm immediately hurt. But what about these ones where cumulative trauma, right? Like my cup's slowly getting filled with traumatic incidents, and one day it's going to spill. So the 3414 is not for preventative, right? You have to be defined as being injured or know that you're injured. Can you speak to that?
Yeah, so the 3414 is about preventative, right? We're preventing the next incident. We're preventing the next hazardous occurrence. There's a lot to take from what your statement. So just so we're clear, the determination process used to take the Lab 1070 or the 3414 as their intake form. But since I think it's June 2023, Kim will be able to correct me if I'm wrong, they've implemented their own forms, both for employee report and employer report of the injury that they're wishing to claim access to benefits for. So it used to be, so you're not wrong, but since then we've really separated the processes to ensure that the real purpose, the requirements and the regulations are not watered down. And so we get to the true hazardous occurrences, and then we're able to identify opportunities for improvements to ensure the health and safety of employees. So really what we're looking at is hazardous occurrences that may or may not have resulted in injuries, but could have if severe injuries up to fatalities. So what we're talking about with hazardous occurrences are actually unplanned, unanticipated work-related occurrences. It's a malfunction in the operational system. So tangibly, you spoke to one example where you're getting in an altercation with an SOC, and although you've applied your training, your intervention options, your tactics, you still ended up getting injured. There was a malfunction in the operational system. So we're trying to see, is there anything above and beyond that we can do to further refine our processes to ensure the health and safety of employees? Another example would be where you're using your police vehicle to ram a subject vehicle according to the protocols, according to the training that you've received. You're applying the techniques. If you successfully ram the vehicle and you don't get an injury, you followed all the appropriate processes. There's no hazardous occurrence. It's anticipated, even if the vehicle is destroyed, and it's anticipated and planned. But where it does become a hazardous occurrence is where something went wrong, and even though you've applied all the processes, the protocols, you still end up with an injury. Another one would be where you're part of a clan lab dismantling team. You're wearing all of the right equipment. You're wearing your respirator. You did the check before going into the situation to ensure that you have the proper seal, and you end up either tearing your suit or you end up smelling a chemical smell. That's where it's an indicator that there was a failure in the operational system. It is considered a hazardous occurrence. We're implementing emergency procedures to get you out of there and get you decontaminated. That's a hazardous occurrence. We do recognize that it's a little harder when it comes to psychological hazardous occurrence or psychological events to confirm whether or not it's a hazardous occurrence. So really we go back to the definition. Is it unanticipated, unplanned, or is it known that you're going to be going in this situation, and whether or not you got an injury stemming from that? If you were affected by that, then we do consider that a hazardous occurrence. But if it's where you just want to record it to have it on your file that you went to this call, maybe you'll develop something in the future, we consider those just in case reporting, and the 3414 is not the appropriate form to record that event.
Sure. So 3414 for psychological purposes, since we are dealing with non-visible injuries, which are sometimes easy to conflate with is or isn't. If it does happen, like if it's a child death and I'm like, this has hurt me psychologically, 3414. I go there and it's just a regular suicide. It's sad, but not any more anticipated sad than normally would affect Chris. No 3414. Fair. I understand that concept. What I will say to the members watching though is, so then what about the preventative documentation, right? Like what about this cup slowly filling up? And I put something in the chat here. Excuse me, I'm going to read from it slightly. But I do suggest that you keep a bit of a log of this because you don't know what you don't know. Down the road, these things might add up. And if we thought they were going to impact us initially, we probably would have dealt with them initially, right? I would have gone seen a psychologist, cleaned that slate, dealt with it a bit more. But things can creep up over time. And so what I say to you is create a log, right? Just a file number, high level, how it felt, what it was, no personal details. Remember, this is protected information. It is our work. You shouldn't be bringing it home with people's individual personalized names, anything in there, but a reference point down the road that you can utilize, that you could go back and say, this call, oh yeah, this call. And when it's time for your PHA, and Nick's really going to touch on this, like I didn't understand how important the periodic health assessment is. It really is important. And sometimes it doesn't feel like it because it gets processed a year and a half after we submit it. But like, listen, set that kind of sarcastic part aside and say, for my purposes, when you go to that PHA, bring your log and talk to your doctor about all of these traumatic events, right? You don't have to necessarily get into the detail, but speak to them and make sure they're documented on your periodic health assessment. There's a spot that speaks to traumatic events. Have you dealt with dead people? If you're doing frontline policing, there should be something that says see Appendix A, okay? Anyway, I don't want to delineate too far, but I think that preventive stuff, members need to do it, and that's how you should be doing it. The Form 3414, as Emily has explained, it has a place, but it's not going to be for that. And so this is how we bridge that gap. And Kim, if you don't mind, or pardon me, Emily, is there anything else you want to cover before we go into determination?
Just quickly, if you do have concerns that there are hazards that are not appropriately controlled from your tasks, there are things that you can do. You can report your concerns through your chain of command, and the employer does have a responsibility under the code to look into what your concerns are. And then if the hazard is not properly assessed and controlled, they do have to take action. They do have to assess that hazard. They do have to implement control measures to reduce that risk to an acceptable level. And so what I want to encourage you to do is to utilize a process that is available to you, which is the internal complaint resolution process. So there's an alternative if you want to record your concerns or your complaints from an occupational health and safety perspective. Still through our programs, it's just a different process. It's the internal complaint resolution process. And beyond that, the only thing I wanted to mention was that while all of our different programs and processes are all important, they're all parallel. And just wanted to reconfirm that the 3414 is not required to go through the determination process or to go through that VAC process, but my colleagues will be able to speak to that more.
Kim, can you bring us through a determination process? Like, how does that start? Where does the ball get picked up from your point of house?
From my point of house, it's
Kim.
Oh, okay.
Can you hear me, Chris?
We can.
Okay, perfect. Sorry about that, guys. I can't get the video working, so I'm on the phone. So Kimberly Bates here, a National Advisor, Medical Case Management and Determination Process. So from our standpoint, Emily had mentioned that this sort of process changed where we developed our own forms to use rather than relying on the 1070 was June 5th, 2023, and lots of emails and notifications went out with that change in process. So basically, there's two forms. There's one that gives the employer or supervisor the ability to submit to health services that their member has been injured, or they're concerned about their member, that they may have been injured as a result of the performance of their work duties. So that's the first thing. So if the member is in an incident or has become ill or injured, ideally the supervisor knows from the get-go. If not, then it is the member's responsibility to notify their supervisor. So that's the start of the process. So the form for the supervisor is a 6583. So that the supervisor completes that, the supervisor must date and sign that and send it in. There is no time stamp on it per se, not like there is with the safety program and the Canada Labor Code, but the sooner the better, because the whole point of the program is early intervention, early treatment. We want to prevent disabilities. So we want to get you in there and we want to get this done as soon as we can. So that's the first thing. So once the supervisor completes that 6583, they send that to health services. And that will trigger health services to reach out to the member and to check in, make sure that they're doing okay, make sure that they have the supports and the services that they need. If there's a need for any temporary restrictions or limitations, then that might be considered at that point in time. But the point of it is really to make sure the member's doing okay, to send out a determination claim package to the member. And that claim package has a form within it, one of which is the 6583. So that gives the, 6584. So that's the member's report of work-related illness or injury. So now we're getting both sides of the story. So we're getting the supervisor's version of what happened, and we're giving the member the opportunity to tell their version of what happened in the situation leading up to their illness or injury. And in addition to this, there's a attending physician statement, and that's form 4056. So if you've ever gone through the disability process, that attending physician statement is the same form that is used for the disability case management process. So that form is the member's responsible to take that to their healthcare provider. So their physician, nurse practitioner, but it does have to be a physician or a nurse practitioner that completes it. If it happens to be a dental injury, it can be completed also by a dentist or a dental surgeon. But those would be more in the dental side of claims versus the physical or the psychological types of claims. And so once that comes into health services, you got the 4056, the member's report of injury, the 6583. Health service already has 6584 and the 6583. That's considered a complete claim. So sometimes it is very helpful to do a determination if there's additional information. So that would suffice as a complete claim. However, if you are seeing a psychologist per se, and there is a report, then providing that would help with the determination for sure. Even though your physician or nurse practitioner may have put a diagnosis down on paper, having the report that gives us a little bit of extra information related so we can link it to the work relatedness piece of it is very helpful. But obviously we can't say what we need until we know what the claim is about. So those cases, we will ask the member for additional information if we need it. If you happen to have had an MRI and that contributed to the diagnosis, then it would be helpful to provide that supporting documentation. So there's certain core forms that are required, and then there's additional information. So we can make a decision without the additional information, but we also need to be able to make the link. So if we have insufficient information to make the link, then it may not be a favorable outcome. So it is really in the member's best interest to provide as much information as they can that would be able to help us support that it was a work-related injury. On the flip side, if it's a dental claim, there is a dental claim form. It's called a 6582, and that's a report of work-related dental injury or illness. So that would be in the cases member gets punched in the face, broke their tooth, has a broken jaw, has some type of a dental injury. Those forms would need to be filled out by your treating dentist or dental surgeon. In the case of you're making a claim for, let's say, bruxism, which you feel is you have PTSD, and now you feel like you have bruxism as a result of the PTSD. So in those cases, one, we would first need to determine that the PTSD was work-related before we can make a consequential recommendation. And in those cases, if we have a favorable determination for the PTSD, having that either a VAC decision letter or a summary of assessment that's provided to health services, or providing that claim to health services first before we can proceed with the dental claim for the secondary condition. In those cases, you would still need to have the attending physician statement, because that's going along with, it's a physical condition that's leading to a dental condition, if that makes sense.
Yeah.
Yeah.
Is it okay, just for, if I interject for a sec, I just gotta break it down for member.
Yeah.
It's like such a bridge of policy and these reporting lines, and then like me working night shift being like, what is happening here? So for the members who are listening right now, the forms that have been referenced are in the materials that you've been sent. And it states who is responsible for what. Adam had a good question, Kim, with respect to the form 4056, the attending physician's statement. We utilize web doctors now often because like TELUS Health or some of these other areas don't have family doctors. Does the RCMP accept that? Can the form 4056 be done by like a web physician if it's not one that requires a physical interaction, depending on obviously what the physician's reporting on?
As long as it's completed by a physician, or you have documentation that gives the same information that we would have in that form, like we need the diagnosis. So if we, and there's other questions within it, if that can be provided by another physician, then we would accept that, of course, and knowing that we do have challenges in healthcare providers across the country. So it doesn't matter if it's virtual, as long as they're able to print it off or get it. Now, I don't know all the systems out there. I'm in New Brunswick, and I know there are, with our system here, you can print off reports and different things as well. So yeah, it can come as long as it's a physician or a nurse practitioner.
Great. And then I just want to kind of clear up, there's some vernacular that we're all going to listen to today. Some of you will know it who's listening. Some of you are going to be introduced to it to the first time, and it's this determination process. And so there's two kind of different determination processes that we as our members see ourselves having to undergo. Veterans Affairs is going to do a determination process on an injury, and so is Health Services. But there are times when one makes it first, and therefore it renders the other moot. And if you don't mind, Kim, can you just briefly describe kind of what that means? Because to everyone listening, the reason that we want a determination process is that is the portal, that is the gateway that allows us access to these benefits. So if you're in the RCMP as a currently serving member, you get a determination process that reflects you were injured. Let's just say I was punched and my neck's really sore now and has been for a year. My physiotherapy related to that will come out of my occupational health services as opposed to my supplemental, i.e. the amount of massages I can get on my body don't just come out of that little pool of money that my benefits give me. The RCMP is going to cover that off. And now that's important. That's why that determination with the RCMP is important. Now, if Veterans Affairs makes that determination, Nick, I'm not trying to mow your grass here. I'm just trying to sew these two together because I know you're going to talk about it. It's Veterans Affairs makes a determination. If they say, yes, that is a work-related injury, they will tell the RCMP that. The RCMP adopts that and says, yes, this was a work-related injury, and you may be able to get occupational health support, which the RCMP still needs to undergo its determination on that, but you also would get like a monetary amount associated to that. And so that's the vernacular. This determination process for the exploratory aspect of did this become a workplace related injury and the validation of it is crux. So Kim, do you mind just quickly talking about the relationship with Veterans Affairs, how it works if they make a determination or you make a determination, and what needs to happen? Because serving members of the RCMP who get a determination still need to get occupational health care benefits. So how does that work? And then Nick, we'll give her to you.
Yeah. Yeah, so I won't speak for Veterans Affairs because I'll let them say their own piece. But from the RCMP side, if a member has already applied to VAC and they have a favorable disability decision letter, then that gives them access to occupational health care benefits. Now, I understand Amy Moser will be on the line as well. So she'll talk about how they get access to those occupational health care benefits. So for us, we wouldn't do a determination. So let's say PTSD has already been awarded by Veterans Affairs Canada and the member is coming looking for some services related to that condition, then they would go through the health service office and the benefits program there with that letter. So we wouldn't be doing a new determination on that per se. We're doing determinations when the determination hasn't been completed. So we would honor Veterans Affairs decisions and we wouldn't determine it again a second time. So ours is really members should be coming to us before they've ever gotten to Veterans Affairs in the ideal world, because Veterans Affairs is when they have a chronic condition that's been a work-related injury. Our process is really intended for that early intervention so that you come in before you've had that chronic condition for 6 months. You come in early from the time you got injured or when you first became aware that you're starting to exhibit symptoms of maybe a PTSD that's cumulative exposure to a bunch of traumatic different incidences over your career to date. So coming in early before it's that chronic condition. So we want to get the member connected with us, getting connected to that treatment before they go to Veterans Affairs. But we know that that's not always the case, so sometimes they do end up with Veterans Affairs before they've come through the determination process. In which case, at that point, they've already got the decision that's been made and we honor it through Veterans.
Great.
Does that make sense?
Absolutely. Kim, is there anything you want to add before I kind of touch this over to Amy and Nick?
I was just going to mention a little bit about how the process works. So the level 1 decision, so if it's a medical or a physical or a psychological claim, they're done at level 1. So that's the division level, and it's the health services nurse that does the determination at level 1. And so at that division level, they can only find it favorable. If they're not able to establish it as a work-related injury or illness, then they have to move it up to the level 2 National Determination Unit, and we'll do a level 2 review on it. So that's just important, I guess, to know that they don't just blindly get denied at that first level. And if that's happening, then we should be certainly made aware of that. The other thing is making sure that members are aware sometimes claims will get turned back because they're incomplete. So if we don't have a complete claim, we don't proceed with a determination. So that doesn't mean it's been denied. It means that it's been put on hold until we get additional information. The only way a determination can be denied is at level 2. And at level 2, we would issue a decision letter that comes out under the DG of OHSB, or the new title now. So it's Executive Director of Occupational Health and Safety Branch with Sylvie Chateauval. So with that decision letter, the member does have the opportunity to grieve that decision. If they're not in agreement with the decision, and they must grieve that within 30 days. The other option for the member is if they feel that there's new information or they've seen a new provider and they have new information, they can always submit it to level 2 again, and then we can re-review it with the new information. Now, just to be clear, it is new information, not just the same information that's put on a different form. It has to be a new specialist report or some type of new test result that we would be able to kind of reopen it and revisit it with that new information. And I think other than that, let's double check, make sure I've covered everything. The big one is having a diagnosis. So one of the things that we do see sometimes is symptoms of TMJ, for instance. That's not a diagnosis, it's a symptom. So there needs to be definitive diagnosis given in order for us to issue a decision letter. And that's just one of the things that I know can be frustrating, but we can't determine something that's a symptom of something. Symptoms of PTSD is not the same as PTSD. You have to have a diagnosis.
Awesome. Thank you so much, Kim. And now,
okay.
Amy, this takes traction. Can you succinctly kind of bridge us into what is occupational healthcare? What is supplemental healthcare? What is the difference? Why do I care if I have this kind of what we've talked about, a determination? And then we're going to bring it over to Nick, who's going to open our eyes to this whole other thing that many of us had no idea existed. You may or may not know you're on mute.
Can you hear me now?
Yep.
Perfect. Okay, so members who are in receipt of a positive determination or a VAC pension award can now access occupational health care. And the way to do that is that a treatment plan for whatever treatment is required would have to be submitted to the Divisional Occupational Health and Safety Services for review by the Health Services Officer. So they'll review the treatment plan and determine whether or not the treatment is reasonable for the injury or illness and or will assist the member in maintaining their fitness for duty. If that is the case, then the divisional office will create an authorization number in Medavie Blue Cross's system to allow the provider to bill directly and or for the member to submit claims against that authorization to get paid for occupational health care. It's important to know that occupational health care treatments are not subtracted from the annual allowance of supplemental healthcare benefits. So in the $4,800 global maximum, let's say for physiotherapy, massage therapy, chiro, and acupuncture, like you have that envelope of money. But if you're approved for occupational healthcare, any benefits paid under occupational healthcare would not be related to the pocket of benefits under supplemental healthcare. So it's important to submit your treatment plan to have that evaluated. If for whatever reason you've had some treatment paid under supplemental healthcare that was related to your occupational healthcare injury, there is a process by which the benefits can be transferred over from your supplemental healthcare allowance over to your occupational healthcare benefits so that it liberates that amount under your supplemental healthcare benefits. So once the determination is made, the divisional office should be looking at any benefits that had been paid in relation to the injury and migrate those over.
Awesome.
So, oh, go ahead.
No, it's good. Like again, years into the RCMP, because I barely used my benefits, I didn't know or understand. And if somebody said supplemental or occupational, I would have thought they meant the same thing, but they just were using fancier interchangeable words. Completely different.
Yeah, they are completely different. I mean, it's important for members to understand that difference as well, so that it's not harming their annual maximums under supplemental healthcare. If the treatment that's requested is not listed on RCMP policy or in the benefits grid, there's still a possibility that it could be evaluated. We do have a mechanism through the Health Benefits Advisory Committee and the Drug Formulary Management Committee that can review these types of requests if they are endorsed by the HSO. Now, normally the information that's required for that is that you would have to get a letter from your treating practitioner endorsing that. Some information as to how long you would be requiring the medication, et cetera, or why the treatment is required for the injury. And then the HSO would package that up, send it up to the committees at my group, and we would evaluate this with the National Medical Advisor and or the chief the chief psychologist. So to determine whether or not we would endorse this as a committee to go forward for the financial authority through the OHSB. So the executive director of the Occupational Health and Safety Branch, who has the financial authority and the policy authority to allow for items that are not in policy.
Right. So for the member listening, if you do this, someone high up there in the executive level will assess it on an individual basis and see if they can support you.
Exactly.
It's just so many acronyms, and we know things like 266, 175. We got all when we talk about the code, we're talking about the criminal code. Like this group, my group of friends here, we're talking about the Canadian Labor Code, we're talking about policy. It's just like, apples and oranges. So I just try to break it down to make sure that the members understand kind of how that works for them. And I think you've done a fantastic job.
Thank you. I have one last thing to mention.
Sure.
And it's just that once you are in receipt of a positive VAC pension award, I know that members often think that the benefits that they're allowed are in accordance with VAC's benefit grid. And that simply isn't the case. Because our members have different needs, because they're operational, everything is done in accordance with the RCMP policy and benefits grid. So though a benefit may be available through VAC and not available through RCMP or vice versa, everything is adjudicated in accordance with RCMP policy.
Makes sense. So just because you get from one doesn't mean you'll get from the other. Like, the RCMP may not give out large amounts of marijuana to its serving members, right? Like, although the NPF did change that, and you can as and when fit for duty sort of stuff. But I think the point I'm highlighting is if you have one benefit from another, there's still a determination process. It doesn't just carte blanche provide you with that, and vice versa, VAC to the other. The last question I have, Amy, before we hand over all of the time now to Nick, is do you have a bit of a flow chart that you can maybe throw into the chat that kind of speaks to the occupational and the supplemental and, you know, how we get from each little square? And if not, if you could just forward it to me, and then these members can follow me on Facebook and Instagram at Chris Voller NPF, I'll give it to them.
I can definitely send it that route.
Yeah. Okay, thanks. Thank you very much. Now, pending that, this is kind of the RCMP process. I know for everyone trying to digest it, there's a lot going on, but that's why we have the reference document. That's why we have the ability to watch this again. And now we're going to take this and we're going to overlay it with the Veterans Affairs process. We're going to learn about our entitlements there. So, Nick, without further ado, and thank you for your patience, the floor is yours.
Thanks, Chris. I'll just try and share my screen. Please let me know when you can see it.
Can see it.
Great. Okay, so yeah, I'll get right into this presentation. It'll be a pretty quick overview of disability benefits that are offered by Veterans Affairs Canada to members of the RCMP, as well as veterans who have left the RCMP. And so I'll try to answer broadly a lot of questions that you may have. Obviously, what are disability benefits? What are the benefits of applying, especially while you're still in the RCMP? What are the eligibility criteria? How to go about applying? And what a proper application would look like, as well as evidence that is helpful to us in our decision-making process. How our decisions are made, and finally, what happens after a decision, regardless of the outcome. So in a nutshell, disability benefits can be administered by Veterans Affairs Canada to serving members and veterans of the RCMP in the form of what's called disability pension. So this is administered through both the Pension Act and the RCMP Superannuation Act. So any pension monies that are distributed as a result of the disability pension, they actually come out of your superannuation fund. And so the disability pension is awarded to members and veterans in order to recognize and compensate for service-related injuries and illnesses which have caused a permanent disability. And so you could kind of think of it like workers' compensation, but for the RCMP. And we also, of course, administer similar benefits to members and veterans of the Canadian Armed Forces. So if you receive a favorable decision for disability pension, there's a few things that can potentially result from that. So any one condition, any one medical condition that you receive a favorable pension decision for is going to carry with it a lifetime treatment coverage for that disability through our insurer, Medavie Blue Cross. And so that will be things like prescription drugs. It could be special equipment, depending on the type of condition. It could be physiotherapy, chiropractic care for hearing loss. It could be hearing aids. And so this is especially important after you're out of the RCMP and you're not necessarily collecting or covered under medical or dental coverage through an employer. And so if you have particular benefits in place for that treatment coverage for that condition, then that would be covered for the remainder of your life. And so in addition to that, there are also other programs that are administered by the department which require an existing disability pension entitlement. So those can also potentially be accessed. They're mostly designed for after you release from the RCMP, but theoretically you could receive them while serving under particular circumstances. And then additionally, there's the possibility of receiving tax-free monthly payments for the duration of your life, which are payable immediately while you're serving. You don't have to wait until you've left the RCMP to start collecting this monetary compensation. Of course, this is dependent on how severe your disability is. And additionally, with the disability pension, there is the possibility, if you have a spouse and or any dependent children, so under age 18, you may be able to collect additional amounts for their support. And so there's a lot of benefits to applying. Obviously, I just mentioned these in the previous slide, that you can get treatment benefits. You can get that potentially the monetary compensation for yourself and your family if you have eligible dependents or spouse. And it can also help you access those other programs, especially as you leave the RCMP eventually at the end of your career. So, and obviously it's in your best interest to have illnesses or injuries that are related to your service documented while you're serving. And so that's really something that can help a lot with our decision-making process. The more documentation, the better, as long as it's pertinent to basically our decision-making process, which I'll get into in a few slides. So in terms of eligibility, in order to be eligible to apply for disability pension, you have to have some sort of eligible RCMP service. So this is any service where you've been contributing to the RCMP superannuation fund. And so there's a couple of important exceptions here that are not considered eligible service. So any injury or illness that was sustained at the RCMP depot on or after April 1st, 1994 is not a pensionable injury or illness. And the reason is that cadets, since that date at RCMP depot, before they graduate, they're not contributing to superannuation. So if it occurred before April 1st, 1994, it is covered, but on or after that date, it's not. Now, that's not to say that if you get an injury at depot and then it subsequently gets worse due to your service, you can still get a pension for the worsening, but not like a full pension for the injury or the illness being caused by your service. And I'll get into specifics about aggravation versus causation in a few slides as well. Additionally, if you spent time previously in say a local police service, that is not eligible service. And that normally also includes if you've gone on secondment with the RCMP, say on an overseas mission, that is not service that has superannuation contributions attached normally. So basically, if you were contributing superannuation, you're covered. If you were not, then for that period, you are not covered. And so in addition to that eligible service, you have to have a medical diagnosis, which is confirmed by a qualified health professional, and it has to be chronic, which means that there are signs and symptoms present for a minimum of 6 months. Your disability also has to be, of course, related to your service in some way. So it can be a direct relationship, an aggravation, or a consequential relationship. By a direct relationship, we mean that, say, you got injured on duty, or it's a wear and tear from your service-related duties over many years. In the case of mental health conditions, it could be multiple traumatic incidents or other stressors related to your occupation. For certain other conditions like lung conditions or eye conditions or soft tissue conditions, it could be due to exposure to chemicals or biological agents like infectious disease. So that can potentially be forms of direct relationship to your service. Aggravation would be similar, but where the condition was not caused by your service, say it happened at depot on or after that date, or it was a pre-existing condition when you joined the RCMP, but then that condition got worse as a result of some sort of service-related factors. And then lastly, consequential. So this is where you have a pension condition, which then aggravates or causes another condition, which then you could seek a pension for. So an example of that would be, let's say on duty, you slip on the ice, and you break your right shoulder, you get a fracture, and you get a pension for that fractured shoulder. And then over the years, your fracture might have healed more or less, but you're still compensating to some degree with your left arm because your right arm is is somewhat disabled. And so you develop a rotator cuff tendonitis in your left shoulder. You could then claim a consequential pension for your left shoulder, consequential to your right. So that's another way that we can relate it to service. And so, yeah, it has to be permanent disability related in some way to your RCMP service. Now, if you have military service as well, we call this dual service. So both military and RCMP, they're eligible. If you do have prior military service, though, you may end up receiving a decision under the newer Veterans Wellbeing Act. And so if you were to receive a favorable decision, you would receive pain and suffering compensation potentially, as opposed to disability pension. But it depends on the exact chronological order of your service periods. So to apply for disability benefits, there's an application form that must be filled out. It's called the PEN 923. There's a few different ways of filling it out. The easiest way by far is to do it through your a MyVAC account, which can be set up by calling our toll-free number, which will be provided at the end, or by visiting our website. And so MyVAC account allows you to electronically submit application forms for this program, for other programs administered by the department. It's received instantaneously by us, or pretty much instantaneously. And you can also track your applications and send us secure messages through that portal. So we strongly recommend setting up a MyVAC account if you don't already have one. And then additionally, if you prefer to do it by mail, you can request a paper form to be mailed to you by us. So you can just call us and ask for that, or you could print it off from our website. It's available online, and then just fill it out by hand and mail it to us. Third option would be to visit us in person. So if you live near a location, a Veterans Affairs office or a military transition center with Veterans Affairs staff there, you could visit in person, usually by appointment. Or you can visit a Service Canada location if you're in a more remote area. Alternatively, there is the Royal Canadian Legion who can offer some assistance. If you wish to contact them, you're welcome to, and they may be able to help you complete the application forms. So the entire form must be filled out. All the sections that are instructed to be filled out must be completed, and then make sure to sign and date it. Very important to do so, especially if you're doing it on paper, because if we don't have a signature, we will be coming back to you and asking for that, since we can't proceed without a signature. If it's done through my VAC account, it's an electronic signature. And then when you submit the PEN 923, you can also submit civilian medical records, any sort of reports, as was mentioned before, the reports that you would fill out yourself as a member after an incident. You can submit copies of those. The 3414, you can, if you have one that is relevant to the claim, you should submit a copy of that, because they may or may not show up on your service health records when we request them from the RCMP. There's also a consent form that I believe we ask you to fill out to allow us to request records from the RCMP. That consent form is called a VAC 928, and it's mentioned on the PEN 923 application form. It's in the checklist there. And then, yeah, any other supporting documentation that you want to submit, you can submit it at that time through my VAC account or by the mail. If you're a new client, we also ask that you submit proof of identification. So normally that's photo ID that is not expired, and also provide us with your regimental number. If you've been in the military, also provide us with any service numbers that you've had. And then if you've had any prior surnames, such as a maiden name, then please identify that to us as well, because we need all this information to verify your identity. If you have a spouse or dependent children as well, you should submit proof of identification for them, because we need that in order to administer any additional pension that could be payable. And then lastly, you have to visit a medical provider in order to get a diagnosis confirmed. So if you happen to be having your periodic health examination in the near future, you could potentially have it diagnosed then. Otherwise, we can send you a medical questionnaire from the department, which can be filled out by whoever your provider is. And I'll get into who can fill out those questionnaires in the very next slide. So an ideal claim is going to have a few key components. One is, of course, the current diagnosis. So when you fill out your PEN 923, we ask what sort of condition you're claiming. You don't need to know the diagnosis in order to submit the claim. You can provide a general indication of what it is. So you could say, I'm claiming a right knee condition, or I'm claiming a mental health condition. Ultimately, the diagnosis, that is for your provider to establish in the medical documentation. So as far as the diagnosis goes, we need it to have an acceptable name. So by this, we mean it's a commonly accepted diagnosis in the medical community. It cannot be simply signs or symptoms of a condition. So things like stress and anxiety are symptoms of mental health conditions, but it's not an actual mental health diagnosis. We would need something like post-traumatic stress disorder or generalized anxiety disorder or other specified trauma or stressor-related disorder, among others. For physical health problems like knee problems, for example, pain or joint stiffness is not an acceptable diagnosis. It would have to be something like osteoarthritis or internal derangement, Baker's cyst, chronic sprain, confirmed medical diagnosis that has an acceptable name. Additionally, it has to be provided by a qualified health professional. Generally, this means a medical doctor or nurse practitioner, so similar to what was mentioned earlier about the physician statement form for the RCMP. However, we do have, it is a little broader on our side of things when it comes to certain types of conditions. So depending on your province, we will also accept a diagnosis from a physician assistant. So if you're in the prairie provinces or the maritime provinces, that is within their scope of practice for as far as we're concerned. So they can diagnose most conditions. Most joint problems like knees, hips, shoulders, elbows, lower back, neck, etc., that can normally be diagnosed by a chiropractor. If you're seeing a chiropractor, they can give a diagnosis. Foot conditions can be diagnosed by a podiatrist, eye conditions by an optometrist, and there are some other exceptions. Mental health conditions, of course, by a psychologist or by a medical doctor, nurse practitioner, etc. Physiotherapists absolutely cannot provide a diagnosis, though. So they can provide some information on like your range of motion for joints and that sort of thing, but no diagnosis can be provided by a physiotherapist. And then dental conditions actually do have to be diagnosed by a dentist. We won't accept them from anyone else. So there are a bunch of different rules depending on the exact kind of condition, and you can always call us or send us a message if you're unsure about your provider and whether they can give a diagnosis. We also need the diagnosis to be current. So by that we mean it's not older than 2 years before we receive your application. If you submit it, if it's established after you submit your application, then that's perfectly fine. But going back in time, maximum is 2 years. There are a few exceptions to that. So those would be fractures, osteoarthritis, amputations, degenerative disc disease. And then if you had surgery for a condition and the post-operative diagnosis was provided, that is also acceptable regardless of how old it is. But for any other type of condition, it has to be not older than 2 years before we receive that application. So there's that diagnosis component. There's also on the PEN 923 sections for each condition where we ask for 2 statements. So there's one on the service relationship and one on the quality of life. So this is really in your own words. And what we ask is that you provide, to the best of your ability, some information on, for the service relationship, was it a direct relationship, aggravation, or is it consequential to another pension condition? And then the circumstances, if you're able to provide that. So was it a single incident, multiple incidents? Could you provide dates, location, perhaps? Obviously, no like protected information that you're not allowed to provide to us, but within what you're able to provide us for information, more information is definitely helpful for us, generally speaking. It's pretty rare with the RCMP, but if you've ever been on special duty service, it's also important to indicate whether that is the when the condition was caused or aggravated, because well, we may or may not have to rule on your special duty service. If you don't ask for the ruling, we may not end up ruling on it. But again, this is pretty rare for the RCMP. But if it does apply to you, please do specify special duty service in whatever operation you may have been involved with. And so, yes, additionally, the quality of life statement, in your own words, again, if you could provide us with some information on how the condition limits your day-to-day ability to do certain things like normal activities like driving or walking, that sort of thing, that can also help us in our decision-making. And then an important note on these statements, we do request them for all conditions with the exception of mental health conditions. So if you're applying for a mental health condition, do not feel under any pressure or obligation to submit any statements. You can simply ask us to just refer to your diagnostic assessment by the psychologist or the medical doctor or whoever. So no statements are necessary for those conditions. You don't have to type all that out on your own. It's entirely voluntary for mental health. So some evidence that we will use in our decisions, the primary sources are from your RCMP and, if applicable, military service health records. And so we look at your periodic health examinations as well as your examinations for when you join the RCMP and when you leave the RCMP. If you, or I guess that would really be a periodic health examination as well on your release from the RCMP. And then there may be reports on injuries or hazardous occurrence reports in your service health records. Or again, they may not show up depending on the exact circumstances. So we always recommend that you submit copies, if you have them, of these hazardous occurrence reports if they're relevant to your application. Audiograms as well that would have been done during your periodic health examinations, we'll consult those too for any claim for hearing loss or tinnitus. And then, if applicable, we may consider your, if you have a specialized occupation such as a canine handler or emergency response team, and the years of service that you've had in that role. So that can potentially help us with our decisions for certain types of conditions that cause like sort of a, or that are the result of a cumulative wear and tear over several years. But generally, we are relying very heavily on your periodic health examinations, and what is documented there in terms of your diagnosis and the service relationship. So that is sort of the key piece of evidence that we are often looking at. In addition to that, we also put a lot of weight toward any sort of documentation on the civilian side. So of course, when we send you a medical questionnaire, you would go to your family doctor or nurse practitioner or other provider who can fill out the questionnaire. And they can also provide information on the service relationship to sort of corroborate your application, corroborate also what's in your RCMP service health records. And so the medical questionnaire is very important. Imaging reports such as x-rays and ultrasounds can also be very helpful for us. Surgical reports if you've had operations for the condition. Any consultation reports if you've seen a specialist, and also civilian side audiograms are what we will consider. So any of those civilian documents, they're not going to show up on your RCMP service health records. So we do encourage you to submit whatever is relevant for your condition, and that ultimately you must submit whatever civilian records you have if you want us to have the full picture before we render the decision. So the more information you provide, the better. In terms of the Pen 923, also we rely on your statements there if you've provided them, and any witness statements related to particular injuries or incidents we can also consider. So helpful evidence for us in terms of what I've mentioned in the last slide would be, for example, medical documents which provide clear information on the cause or causes of your condition, roughly, the time of onset, what the timeline has been. Has it been, a chronic condition? Has it been intermittent? Sort of, have you had a lot of flare-ups of the condition, that sort of thing? And an accurate reflection of your current symptoms is also very helpful. Imaging reports and operative reports, as I mentioned, can support the diagnosis that's been provided by your provider. And so this is especially helpful for things like fractures or osteoarthritis, which are a little difficult to diagnose without imaging reports like x-rays, for instance. If you have injury reports or witness statements, that provide details about the nature of the injury, when it was sustained on duty, etc. And whether it was sustained on duty, of course, that's also helpful information for us. Of course, subject to whatever the administrative procedures are in the RCMP, as was already discussed earlier in this call. And then, of course, having detailed statements on your Pen 923 is also very helpful for us. Stuff that is less helpful, although you can still, of course, submit this evidence, but this is stuff that is we sometimes see, but it's not as pertinent for us to render our decisions. So sending us copies of scientific journal articles or research papers on your disability, we don't generally put much weight on those, and the reasons that if your condition is medically complex enough, it's going to get reviewed by medical experts on our side of things. So they are already aware of this sort of medical research, and so they're relying on that already. Generally, we don't need photographs of the disability unless, say, it was something like a scar or a burn or something where that photograph is really integral to, you know, showing what the disability actually is. But if it's like a broken ankle, we don't need photos of that sort of thing. So there's no need normally to submit that unless your doctor thinks it's pertinent. And then if you provide the Pen 923 with minimal statements, we can still potentially work with it, but it's not very helpful to us when the statements are extremely limited. And again, mental health, it's not required, so always keep that in mind. But for other conditions, we really do appreciate having substantial statements on how it's related to your service.
So Nick, you're saying if a member is applying for a pension that they could receive for the rest of their life, that they should perhaps put a fulsome set of details in for you to be able to evaluate it?
Yeah, I mean, ultimately, the applicant statement, we do legally require it for starters, because of course, if you're applying for a pension, you're applying because it's supposed to be related to your service. So
like
we need a justification. Yeah. So and at the end of the day, it also helps us pinpoint, you know, if you're able to provide us with dates, it makes our job far easier going through your records and kind of piecing the timeline together. So the more information, generally speaking, the better. Yeah.
Absolutely. And so, just for the members online, like, we're all investigators. We write our reports to the Crown, our PISs. Like, this is the time to take the medical information, take your documentation, and lay it out in a format that these analysts and these people who are making the assessment are going to have a clear, concise ability to absorb it. This is their criteria. This is what you're saying. This is when it happened. And here's your supporting documentation. Truly, for us, no different than how we do our investigations. So I know I get a lot of like, it takes so long, VAC's behind, I have to give this document. Like, just give them as much as you can to front end load it. And that will also speed up your timeline, in addition to probably assisting in getting you a favorable decision, as opposed to them having to come back or withdraw without the appropriate information. So I don't mean to interject. I know we're tight on time, but I really want to stress that to the membership, because we have really smart people who can do it. I just want to see it happen in the first instance so that everyone's happier.
Thanks, Chris. Yeah, so once we receive your application, it's going to go through several stages from start to finish. So it's going to be handled by several different people, starting with the disability service assistant, who's going to do the intake stage for the claim. This means requesting your service health records from the RCMP, requesting a file number once we've gotten your proof of identification if you're a new client to the department, and just ensuring that your Pen 923 is complete. Once we have all that basic information, it gets moved on to the claims preparation stage, where a benefits program officer like myself will review it for a diagnosis. As long as we have a diagnosis, it's going to get sent to the third stage, the decision-making stage. If we're missing a diagnosis or we need an additional medical report, we will contact you or possibly your provider if we have the consent forms on file. And then you may receive a letter saying the claim's been put on hold if we're missing information. So, but barring that, it moves on to the next stage, decision-making, at which point the benefits program officer or a disability adjudicator, who would be a registered nurse normally. One of those two is going to render a decision on your application, and I'll get into exactly what that entails in the next slide. But ultimately, who deals with it depends on how medically complex your condition is. So a BPO, benefits program officer, is going to deal with medically simple conditions like osteoarthritis or PTSD. Disability adjudicators are dealing with things like concussions and like acid reflux and just more medically complex things. And then in terms of the Legion, I already mentioned it before, but we do have the Legion as an external partner who can assist you in preparing your application and provide you with support and deal with the department on your behalf when you're applying for a pension. So basically, if you go with the Legion and they accept to take on your claim, they're going to take the place of the DSA. So they're going to be doing the intake, but ultimately it is still a BPO or a disability adjudicator who's going to render the decision. The Legion representative does not render any decision on behalf of the department. It's just preparing your claim for us. Okay, so the decision-making process has two potential stages. So at a minimum, you're going to receive an entitlement decision on your diagnosis. The entitlement decision has three possible outcomes. So it can either be fully favorable, and this is where we determine that based on the evidence, your condition was caused by your service. It's a direct relationship. So that would be a 5/5 decision. It can be partially favorable, which is an aggravation situation. So if the evidence shows that your condition maybe existed before you're joining the RCMP, but then it got worse due to your service-related duties somehow, then we grant a partially favorable decision at a rate of 4/5. If we don't have the evidence to show that your condition was caused by your service, then we grant a 0/5 or unfavorable decision. The decision maker will consult the entitlement eligibility guidelines for certain conditions that are commonly claimed. These are available publicly. I'll show an example in the next slide. But they're not an exhaustive list, but they do give you an idea of, for certain commonly claimed conditions, how we render decisions and what sort of considerations we make when it comes to trying and linking your condition to your service. If your entitlement is either a 4/5 or a 5/5 favorable decision, it's usually going to go off to receive an assessment next. So the assessment is where we determine if you're entitled to a payment or not. So the entitlement, if you get a favorable entitlement fully or partially, you're going to get the treatment coverage. But as far as the payment goes, it depends on your assessment. So the assessment's granted as a percentage. If you receive 1% or more, that means that there's a possibility of you getting a payment. I'll get into payments as well a little bit later on. But basically, the criteria for your assessment are taken from the 2006 Table of Disabilities. It's also a publicly available document. And so from that table, we go to the relevant chapter for your medical condition. We get a medical impairment rating based on the criteria there, comparing it to your own medical situation. We add that along with a quality of life rating taken from chapter 2 of the Table of Disabilities, and the total is your assessment percentage. The maximum you can be paid out for all conditions is 100%. So if you get to 100% at that point, we're not granting any further percentages. We can still give you entitlement for new conditions, and you can keep applying for new conditions, but there's no additional payment that we can grant for any new condition at that point. An example from the entitlement eligibility guidelines. So this is a screenshot of our website. There's an A to Z list of the guidelines that exist at the moment. And so let's say you're claiming a right foot plantar fasciitis condition as an example. The decision maker, if we've got a diagnosis for your condition, the decision maker may go and look at this guideline and consider specifically the pension considerations found in the page, and determine whether there's potentially a pension consideration that helps us more easily link the condition to your service. We're still going to look at your service health records and your medical questionnaire and see, what is there that links it to service. But the guideline can also help us just make the link more easily and more so in your favor. So let's say the decision maker determines that, yes, you're going to get a 5/5 fully favorable entitlement for your plantar fasciitis. It was directly caused by your service. At that point, the decision maker, assuming you can still receive an assessment, you're not at 100% yet, the decision maker will go to the Table of Disabilities. The chapter for foot conditions and other musculoskeletal conditions is chapter 17. So the decision maker will go to chapter 17 and consult the table for the foot and toes, which is table 17.13 in this case. And then let's say that your medical evidence shows that you have right here an included condition with mild to moderate daily symptoms with or without treatment. If that's what the medical evidence shows, we will grant you a medical impairment rating of 4. And then on top of that, we'll grant you a quality of life rating of 1. So we'll do 4 plus 1, that's 5%. That is your assessment. If you get the 5/5 entitlement, you're getting paid at the full assessment rate of 5%. But if you get a 4/5, then you're going to get 4% instead of 5. So it may result in a reduction in the total payment that you get, depending on the exact circumstances. Just a quick note, if you have dual service, if you have RCMP and military service, it's possible to get what's called split entitlement, where you get 2/5 to RCMP and 3/5 to the military, or 3/5 to the RCMP, 2/5 to the military, if the condition is related to both of your periods of service. So you might be paid out some under under disability pension, some under pain and suffering compensation, but that's not a very typical situation. It's pretty rare. Another example with hearing loss. So your hearing loss decision is going to be based on, if you apply for hearing loss, we're looking at your audiogram and we're seeing what your decibel losses are on the audiogram. So if you have a minimum amount of decibel loss at certain frequencies of hearing in at least one of your ears, we look at 500, 1,000, 2,000, and 3,000 hertz. And so we add all of those decibel losses together. And if you're at least 100 decibels in one ear, we consider that a disability, and as long as it's chronic, we can consider that a permanent disability, and you might get a favorable decision. Obviously, it also has to be related to service. But as far as the assessment goes, we're going to basically look at your better ear and down here and your worse ear, and in the grid, we'll select which medical impairment rating is most appropriate based on the readings on your audiogram. So that would be another example of an assessment through the table of disabilities. And then just for mental health, I'll briefly touch on this. It's a long chapter, chapter 21 for mental health conditions. And your rating, if you get a favorable entitlement, it's based on 4 different tables. So we add the ratings from each of those 4 tables together based on the medical evidence. And then you get a quality of life rating too. So you get a full assessment. You know, it might be 25, it might be 35, 55%, depending on the total severity of the condition. But an example, table 21.4 is on treatment needs. So we're going to look at your medical evidence and see, do you take medication for the condition? Do you see a therapist or psychologist, etc.? And then we'll determine the appropriate rating for this table based on that evidence. I put in a slide here, more or less the halfway mark. I think it's probably more like 2/3 of the way through. If there's any questions, but Chris, if you prefer, I can go through the whole thing, up to you.
Yeah, I think for the most part, I'll just pause here. I've been answering as many in the chat as has Emily and our other panelists. Anyone who has something that hasn't come up, type. You got 30 seconds. Otherwise, we're going to keep her moving, just cognizant of time. Keep it going, man. Yep, it's a quick 30 seconds.
Okay.
Thanks, Nick.
Man,
right. Always one person. Okay, back to the first slide. Your injury cannot be older than 2 years, or does that just mean the diagnosis?
That's the diagnosis. The diagnosis. So
you need to get a diagnosis again to show it's fresh. The injury can be outside of the 2-year claim, but VAC wants recent information to be able to make their assessment to show that hasn't since healed, right? Like they're trying to show that that's still relevant. It is still chronic, which they define as 6 months, but they give it a 2-year window. So if your injury is outside of 2 years, you can make your PEN 923E application, but the diagnosis will have to be within the preceding 2 years of the time you're making that application.
Yeah, except for those handfuls of exceptions. Like if you have an old fracture from 25 years ago on duty, you can claim that as long as there's the old medical evidence, we'll accept the diagnosis. But it's probably totally healed, so you might get a favorable for it, but maybe 0% will be your assessment. You might not get any payment because it's healed, but we'll still consider it a current diagnosis. If it's a fracture, Amputations also, it doesn't matter how old the diagnosis is. If you've got like lost the tip of a finger or something like that, you can claim that as long as the diagnosis is in the record somewhere and it's clear enough. So there are exceptions, but yeah, absolutely. We want just the information that is most recent to ensure that you have a current disability resulting from the injury. But the injury could be 30 years ago, 40 years ago, doesn't matter, as long as there's a current diagnosis. Okay. Yeah, so in terms of once the decision is rendered, basically we'll do data entry on our side of things, and you'll receive a decision letter with all the pertinent details that it's written up by the decision maker. So if it's favorable and you receive a payment, then it's going to be reviewed by a payment officer who will calculate any retroactive payments you're entitled to, and they'll modify your payment schedule, and then the package will be mailed to you with all the information on direct deposit or whatever the case may be. If it's favorable but there's no payment, then you're going to get the letter sent to you pretty quickly by the decision maker. There are cases where the assessment won't be final. So like, let's say we have enough information to entitle your condition favorably, but we don't have any information to assess. We don't have any information on the current medical situation. In that case, we may follow up with you through your area office's disability assessment group to get a proper assessment done at a later date. Same thing goes if you have surgery, like around the same time you get the decision. We will consider that not medically stable, and we don't want to give you an assessment necessarily at that time, because we want a proper assessment on file once your condition is kind of after the 6 months or whatever after the surgery. So yeah, you may hear back in certain cases like that. If it's unfavorable, then you'll simply receive the letter in the mail. It'll be sent directly, and it'll have information on next steps. And then we have an internal document called the Summary of Assessment, which is updated every time you have a new decision that's processed through our system. And so you can request a copy of the Summary of Assessment at any time if you just want a record of where your decisions are at, which conditions you received decisions for already, and what the details were for each one, how much percentage you've gotten for each pension condition, etc. If you receive a favorable decision and there's a payment attached, you're going to begin to receive your tax-free monthly amounts. Now, assuming you receive a disability pension, which is normally the case with RCMP, you're going to only be able to receive monthly payments. There's no lump sum option, except that if your total pension is less than 5%, so if it's 1 to 4%, at that point, it's an automatic lump sum, and there's no further monthly payments until you get to that 5% threshold. After that, it's always monthly. If, though, you do have previous military service and you happen to receive a pain and suffering compensation, this has two options. It can either be monthly or a lump sum payment. However, the monthly payments for pain and suffering compensation are lower than the disability pension. So for what it's worth. You can additionally use your Medivie Blue Cross card that will send you to pay for treatments and services. Now, mind you, you'll probably have quite a bit of coverage while you're serving in the RCMP, but I think maybe Medivie might cover other stuff. I'm not sure, but you can always contact them if you have questions about specific coverage. And then if your condition worsens in the future, you can contact us and ask for a reassessment to see if your percentage could potentially increase. And I'll talk about that in a couple of slides as well. For specifics on payments, to give you an idea, an example, we have the full rate tables on our website, and I believe there's a link in what has been provided in the chat or in the documents, the links document. But let's say you receive 10% for disability pension. We call this Class 19 pensioner, the Class 19 pensioner rate. So there's 21 classes. Class 21 is the lowest one at 1 to 4%. Class 1 is 98 to 100%. So that's the maximum possible payment. You get rounded to the nearest 5% for payment. So if you're in receipt of 7% disability pension, you get rounded down to 5%. If you're in receipt of 13%, you go up to 15%. But okay, let's say you have 10% disability pension. That's what you're being paid at. The current rates as of this year are, if you're single, you get every month tax-free $345 almost. If you have a spouse, you get an extra $86 and change. And then if you have children who are dependents, the first child, it's about $45, second child about $33, and then each additional child about $26. So as an example, if you are a Class 19 pensioner with a spouse and 4 children, you will receive $559.74 a month, tax-free, and that gets indexed every year based on the preceding October CPI. So it gets indexed every January. So yeah, that would equate to $6,770 a year roughly. And then to give you an idea, you could multiply all of these figures by 10 to give you the amounts if you were in receipt of the full possible pension of 100%. So we're talking almost $5,600 every month, or about $67,000 a year in tax-free amounts. So that gives you an idea of the amount that can potentially be received. And then as far as reassessments go, if you have an assessment percentage and you request a reassessment, that assessment percentage could go up or down if you're holding a disability pension. So yeah, it could increase or decrease depending on the circumstances. Decreases of the percentage can happen if you are below age 55, or if the assessment that you have has not been in place for at least 3 years. So if you're 55 and up and your assessment has remained the same for 3 years, it's locked in. It won't ever be decreased. It can be increased, but it won't be decreased. But if you don't fulfill, if you're not in those criteria, it's possible for the condition to have a decreased assessment on reassessment. So, but basically reassessments can be done. For instance, if your original assessment wasn't final, we call this an interim assessment. So again, that would be if you had surgery very recently, or if we didn't have enough medical information to do a proper assessment, then we may contact you and ask for new medical documentation to get a proper assessment on file. There are cases where we might, if you have a very severe injury, we may grant a temporarily high assessment, like maybe 40 or 50%. But then after 6 months or a year, we expect that that condition is going to stabilize, and then we will ask to do a reassessment of that condition. So there are cases when that can happen where we reassess periodically. Otherwise, you can, of course, request a reassessment if your condition has worsened. So you have the right to request those reassessments as long as you haven't got to 100% pension. Okay, survivor benefits. So if you were to pass away and leave behind a spouse or any dependent children, they may be eligible for a survivor pension. So basically, if you already held a disability pension of 5% or more, any eligible survivors will continue to receive that same rate for 1 year. And after that, they're going to transfer over to a survivor rate. So if your pension was between 5 and 47%, the survivor pension is going to end up being less than what you were previously receiving. But if you had at least 48% pension, the survivor pension is automatically going to be paid out as if you were a single pensioner at 75%. So it could actually be a substantial increase depending on where you were at. So it's a little complicated, but the rates for survivor pensions are also available in our rates document on our website. Yeah, and as far as survivor pensions go, I mean, there's a certain rate for the surviving spouse, and then there's extra rates for orphan children or dependent children of that surviving spouse.
Quickly, Nick, sorry, when you say dependent children, can you just elaborate? So the children is 18 and under.
Yes.
Dependent, so individuals with perhaps a disability, or like as defined by the CRA, or whom?
I'm not exactly certain how the survivor benefits are considered, like as far as dependent children go. I think disabled children can be eligible regardless of age, if I'm not mistaken. It is dealt with by pay, not really by disability benefits personnel. So I don't want to say too much.
No, fair, I can.
Something incorrect,
they can, for sure, as an adult for the rest of the life, as a dependent to the individual, and then later as a person who is providing it when we die as the serving member. I just am unsure if it's defined by the Canadian Revenues Agency as what that disability is. But for anyone who may find themselves in that circumstance, reach out to me. I'm happy to look up the legislation because it'll be defined within the legislation of the Pension Act. So anyway.
Yeah, and there's a lot of provisions in the Pension Act too. I mean, it's even possible to get pension potentially for dependent parents of the RCMP veteran, depending on very specific circumstances, or even dependent siblings, I think. So it's rare to see that sort of circumstance where there is eligibility, but yeah, there's a lot of stuff in the Pension Act that's kind of deep into the act later in the later clauses. So yeah, absolutely. Your survivors can also apply for reassessments of your condition. So if you had medical documentation that would have supported a reassessment, they can apply for that. They can also apply for new conditions that you never got a pension for. And then if your death ended up being the result of a pension condition, then your survivors can also apply for what's called a death ruling. And if the death ruling is favorable, then your pension condition that resulted in your death, ultimately it increases to 100%, and they're going to receive the maximum possible survivor's pension, as far as I understand it. So say if you received a pension for cancer or something and it ended up being a terminal cancer, after passing away, a death ruling could be provided, and then the assessment for that could be increased to 100%. Okay, so quickly on the additional benefits that are available potentially if you hold disability pension. There's 3 of these. So there's the attendance allowance, the exceptional incapacity allowance, and the clothing allowance. These are all tax-free amounts. They're in several different grades. So depending on the severity of your situation, and the dollar amounts are all on the slide there. But basically the attendance allowance is provided if you are totally disabled and you need to hire an attendant to assist with your activities of daily living. And so to access this, you have to have a minimum of 1% disability pension, but you also have to be totally disabled, as defined in the table of disabilities. It's in Chapter 6, I believe, the table. The exceptional incapacity allowance is additional compensation for if you're exceptionally incapacitated, and you have to have a total disability assessment of 98%. At least 1% of that has to be disability pension. If you're RCMP, though, it's probably all going to be disability pension if you ever get to that point of 98%. And then that's defined by, I think, Chapter 7 in the table of disability. So the information is all in that chapter. Clothing allowance is basically to offset your expenses for a pension disability that requires specially made clothing, or if it causes wear and tear on your clothing or soiling of clothing, something like that. So yeah, clothing allowance can also be awarded in 10 different grades depending on what your needs are. And so that is defined based on Chapter 5 of the table of disabilities. And so all of these can theoretically be accessed while you're serving. But as far as attendance allowance and exceptional incapacity allowance goes, in general, it's really more for released members. And the reason is that the criteria here is that you have to be very severely disabled to be able to access these 2 programs. Theoretically, yes, you could still be serving in the RCMP. It's not impossible to access them, but generally this is more like when you're in advanced age and, you know, you're pretty severely disabled, that sort of thing. So, but yeah, it is theoretically possible to get it while serving if you're truly in an exceptional incapacity sort of situation. And then the clothing allowance can be accessed potentially while serving or after leaving the RCMP. So, okay, if you disagree with the decision, whether it's favorable or unfavorable, you have the right to request a review or an appeal of it. Every single decision letter that you receive from the department about disability benefits decisions is going to have details on what your rights are and how to exercise them. So depending on your exact circumstances, your recourse may be with the department through what's called a departmental review, or I should say, through the Veterans Review and Appeal Board, or the VRAB. So it depends on exactly the circumstances of the decision and your current situation. But basically what we strongly recommend, if you're in this situation where you want to contest a decision, is to contact the Bureau of Pensions Advocates. They provide free legal advice and representation. And so they're really the ones who are best equipped to help determine which is the best course of action, whether it is going for a departmental review or going to the board directly to review or appeal the decision. There are other options here. You could hire your own attorney, although that would be, of course, at your own expense. You could contact the Legion, who also can represent you potentially in the appeals process, or you could represent yourself before the department or the board. But it's important to note here, if you do represent yourself, departmental review, it's got a very specific criterion for when it can be used. So probably if you're disagreeing with the decision rather than alleging that we made a legal error or something like that, then it's really to the review and appeal board that you would go to. And some final information just to add on to that is that, again, if we're missing any important information, we may put your claim on hold. If we do put your claim on hold, you don't need to worry or panic or anything about it. It's easily can be dealt with. Basically, we request that the information that is asked be provided to us. And then once that's done, you can just contact us by phone or through my VAC account and ask us to reactivate the claim. There's no need to submit a new application form if your claim has been put on hold. So yeah, just contact us and we'll reestablish the claim. Please stay in touch as well once you apply. So keep an eye on your voicemail, your physical mailbox, and your MyVac account, because we may have to contact you through one or multiple of those means, several of those means. And then normally if you hold an entitlement for one condition, it's usually going to include all other similar conditions. So if you have osteoarthritis of the right knee that's entitled, you don't need to go and apply for Baker's cyst or internal derangement or chronic sprain. It's all covered by your osteoarthritis, but you can request a reassessment if the condition overall has worsened. There's one exception there. If you hold a mental health condition entitlement, but for say generalized anxiety disorder, and then later down the road, you get a diagnosis of PTSD. In that particular case, you can absolutely apply for PTSD if you would like, and we will provide a ruling on that PTSD condition. It may not result in an additional payment because basically it and the other mental health condition are lumped together for the assessment. But if you want to have that diagnosis recognized by the department, then absolutely we will consider a new application for PTSD, regardless of your previous entitlements. Okay, so that's all that I have. So I'm happy to answer questions through the chat or however, whichever way. There is some basic contact information here though, so you can call us toll free at one of those two numbers, English or French, and we're available Monday through Friday during those hours for 8:30 to 4:30 local time. And then there's also the number there for the Bureau of Pensions Advocates. And I believe that's a voicemail thing. So basically just follow the instructions if you're looking to review or appeal the decision. And they should get back to you once you've sent them a voicemail.
If I can, Nick, there are a couple of questions. I'm cognizant of everyone's time. So thank you everyone who's remained online. Nick, how much time do you have, since really you're now the focal point before I do some closing remarks that I think everyone would be able to live without?
I have all the time in the world. I'm not in a rush.
Okay. I'm going to take them from the question and answer portion. I've been trying to do the webinar chat and both go back and forth. So if you have a question that hasn't been answered, if you guys could put it in the Q&A portion for me, I'm going to run through some of these. Nick, with respect to the 55 years and then having held the pension for 3 years, are the two synonymous? Must you be 55 and have held that pension for 3 years?
Yeah, you have to be both over 55 and your assessment has not changed for 3 years in order for it to be locked in.
Excellent. So I can't be 23 and have held it for 3 years and now it's good. It must be 55. Both Pillar A and B must be present.
That's my understanding. And that is in the Pension Act as well, in one of the clauses. Yeah.
Okay, that's perfect. That was one of the questions that came up. Does VAC provide access to physicians for determining a diagnosis, for instance, where a member cannot access a physician for whatever reason? Now, I know the military bases have physicians on base. That's not the RCMP circumstance, but are you aware of any VAC designated physicians or locations where an RCMP member could attend that location to have one of these determination processes undergone? I believe that's the question.
Unfortunately, we don't. I mean, our staff of physicians is very small. We do have some physicians who work on the disability side of thing, but they're basically determining like decisions or assisting nurses with very, very complicated medical conditions and figuring out what the diagnosis is and that sort of thing. So we don't have medical doctors who do diagnostic stuff for first applications. It's possible, depending on your circumstances, if you're going for a reassessment, you may be able to get an assessment done by, they're called a senior area medical officer, a SAMO. It's not commonly done by them, but it is possible if you're near a VAC location. But yeah, if it's a first application, unfortunately, we don't have the resources to provide a physician to do that. So it would have to be through a provider on the client side of things. But again, it could be for certain conditions, it could be a chiropractor or a podiatrist or an audiologist for hearing loss and tinnitus. It doesn't always have to be a doctor. And I know that it's hard to find doctors these days. So yeah. Was that the full question?
I think that's it. I would also say to anyone watching, through the NPF, you do have access to TELUS Health. And TELUS Health does have some locations that are in person where you can attend these TELUS centers to get some of this stuff done. I know we're everywhere, right? I did 9 years in isolated posts, and like, that's not at all helpful, Voller, so shut up. But for some people, it might be. For those of us who are working in the bush, unfortunately, we don't have it, and we got to find a way to get doctors. We are working on that as the NPF. Now, Nick, can you talk to me a little bit about three common things? So members wear a lot of kit, right? Like, so we've got our vests, we've got our duty belts, we've got all of this required equipment. We call it service order number 1. I know with CAF, like rucksacks, et cetera, you're well aware of these things that are required of us. So cumulative joint trauma, can we go over that? Can we also go over like plantar fasciitis? Like, how do I draw a nexus to that? Like, besides going like, look, the RCMP provided me with the world's worst boot and I have to wear it plus all this equipment. Can you give me a sense of that? And then the last one, because I lose my train of thought easily, is can we talk about tinnitus, since I think that's a fairly common one for us as well. And if there's not hearing loss, because I know that's its own thing when we look at the decibel, how do we show a nexus to work for tinnitus?
Wonderful questions. I think with as far as things like plantar fasciitis or hip conditions, knee conditions, that sort of thing, cumulative stuff. As far as we're concerned, like the gold standard is that you would have basically on your periodic health examinations and your medical questionnaires asked by the department, documentation not only of the disability but the cause, and have it linked to service that way. That is by far the most beneficial way for us to kind of see the service link. Cumulative joint trauma, it's in the entitlement eligibility guidelines. There is a document for that. That is specifically for osteoarthritis of the knees, the hips, the ankles, and the lumbar spine. So it doesn't apply to other conditions of those body parts. So if it's hip impingement, we can't use that guideline. Or if it's a internal derangement of the knee, we can't use it for that either. It has to be osteoarthritis only. So like cumulative joint trauma, it's ultimately, it takes into account how many years you've been in and what sort of trade or occupation was being occupied. So I can't go into specifics about exactly the trades and the years of service and that sort of thing. I can, of course, refer people to what's publicly available on the entitlement eligibility guideline. But ultimately, we prefer having just concrete physician or nurse practitioner, whoever, saying, this is the disability and this is what we believe to be the cause, wearing this footwear or wearing the duty belt or carrying heavy equipment or what have you related to service in the RCMP. That's sort of what I would say the gold standard is.
Sure. So those periodic health assessments are truly crucial for you guys, for us to have that doctor saying like, look, my duty belt is grinding me, or my gun is continually wearing against my hip, or I'm going to say like the carriers one in particular, lower lumbar. You're sitting in a car for hours at a time and your handcuffs are just digging in to the back because we don't have a cushion that resets because no other human being decides to wear a giant fanny pack of metal across their back. It's just not smart. Although recently the RCMP did approve a padded duty belt, which we're excited about. You, until recently, had to actually have a disability before you were allowed to have access to it, but now you can just get that. So members who don't know, 1216 is the form you have. You do not need a doctor's note. Moving on. For those of you who have a disability as a result of it taking 152 years to get here, this is how you would make your application. Now, going through that, also the PHA is super important, as we talked about earlier, and just segueing this back for everyone. We also want to look at the members report, the form 6584, right? So that's you as a member reporting you have an injury. That is what we talked about and Kim talked about. And then that form 4056, the attending physician. So that's also documentation supporting information that would allow you to access occupational health care. And that's like preventative. So to the point where it's not 6 months, like don't wait 6 months where it's chronic and meaning the definition where you want a disability. It's preventative. Like let's get those massages in and try and straighten out your spine or your knees or whatever that may be. Should that not work out because you're going to do this for 25 years, then we'll move on to the Veterans Affairs support, but that's the nexus. Rolling through here, chronic back pain. So I know pain is a symptom, but you had said that one of the diagnostic standards for cumulative joint trauma, can we say osteoarthritis in the lower lumbar meets that? Is that one of the ones that you went through? And my apologies for not retaining that.
Yeah, no problem. It's cumulative joint trauma. It's osteoarthritis of the hips, knees, ankles, or lumbar spines specifically.
Brilliant. Thank you so much.
There was that thing about tinnitus as well,
yes.
if I recall. So was that the question about tinnitus without significant hearing loss that I'm seeing?
Yeah.
So basically with tinnitus, I mean, you can of course refer to the entitlement eligibility guideline. It is actually pretty helpful for that. Basically, tinnitus it can be due to I think the guideline talks about acoustic trauma as well as like sort of more cumulative noise exposure that causes hearing loss. So when you're claiming tinnitus, regardless, I mean, we do generally need those audiograms in order for us to rule on the tinnitus. Again, I would obviously, like, I can't coach anybody to say, you know, apply this way and say this thing, of course. So we can't say anything like that, but definitely educate yourself on what's in the entitlement eligibility guidelines that are publicly available. Yeah, that's really all I could say at this time.
Sure, that's fair. And that information is located on the VAC website. And just for everyone else's information, we have included some of those hyperlinks within that document that I'm just going to throw in here into the chat one more time. So that anyone who joined late doesn't have to scroll through everything to get it. For anyone, there's a question, Matt LaBelle, my apologies, I was trying to answer it here, but for some reason my computer screen's not allowing me to type at this point. I must have used my max characters. If you have a VAC positive determination, then you would send that determination letter in to the RCMP so that they're aware of it to get your occupational healthcare support. That is what would need to happen if the positive determination didn't come through the RCMP and it went without that process to VAC. VAC makes that determination. If we want to go backwards to the RCMP because we're still serving and get occupational healthcare support, then we provide them with the determination letter. They will honor that, with the caveat that not all benefits for the support are exactly the same when it comes to what it is that they have a matrix for what this condition entails for support versus what VAC does when we discharge. Just in recapping, I think it was Kim's points earlier, or perhaps Amy's, my apologies. Okay, so running through this, I'm gonna cap it at noon, just because we could be here all day, which was the whole point of us wanting to have this seminar and this learning ability. Very, very gracious and thankful for your time, panelists. We know that you specialize and have other things to do. So we'll just say at noon. When we come down here, Nick, maybe you want to just pick some of the ones through this Q&A that you think you can answer the fastest, and we'll go through volume. That way we can hit as many topics as possible.
Sure. Let me just have a quick look. There was a point here about the Medivie Blue Cross card. So yeah, yeah, it is honestly quite possible that the treatment coverage is not available while you're serving. I do not regularly, where I don't work with RCMP files. I have familiarity with it, but I know that those in the military who are serving full-time, they don't get the Medivie Blue Cross card and they don't get coverage from us unless they're in the reserves. But yeah, it may well be the same exact thing for the RCMP if you're serving then. So yeah, if you don't receive a Medivie Blue Cross card in the mail, then I guess yes, your treatment.
They don't. You get it's called an H card, and you'll get it when you discharge. So at 1733, up until then, your occupational health care is meant to be what covers you. When you're released, when you do that 1733 and we move on to the greener pasture, then we get the H card, and that's when those VAC benefits move from the RCMP over to VAC.
Okay, yeah, it's a similar process then with the military, I think. Okay, yeah, sorry for the confusion there.
Not at all. It's complicated, and really to everyone's point, like, so this was super informative. We kind of peeked behind the curtain of like, when do we use the 3414? Did we even know that this form existed about members who are injured? Like, I truly didn't. I was like, I thought a 3414 covered that. I wasn't aware that we had this 6584 or the other ones that relate specifically to dental. These are the things that members need to know, because as you pointed out, Nick, you guys and Lynn down the road, when you're looking for evidence, when you're looking for that documentation to see if we meet the legislated criteria, because it's not just what you want or how you feel, there's tables of disability that are built in through legislation, and we either meet or do not meet that. And that is what's going to provide the evidence for the member, as well as hopefully a fulsome context when they make their submission on the PEN 923E. It really is a lot. And that's why members can go back. And that's why Megan has graciously put together this kind of 2-pager with breadcrumbs of here's a hyperlink, here's how this works. But for years, no one's told us this, and we'll circulate this video to allow members the opportunity to learn. And, you know, I would like to do one of these en français so that some of our members who are perhaps better learning in French will have the opportunity to absorb it, and then maybe another one of these down the road. But I think it's been very successful, and I think we'll just wind her up here because the closing comments here, there's a ton of stuff going on. I've tried to say that we're going to stay away from the individualized questions because I want to keep it high level, and I also don't want to take up anyone's time. I see a couple of notes from panelists. I have another meeting, and I'm very appreciative of that. So everyone who joined us today, thank you so much for your time. What we will do is we're going to have a follow-up email through the NPF ones that most people, I think, often just delete. So tell your friends not to, because we put out so many. That's okay. The comms team, if you watch this to the end, comms team, I'm sorry. But really, make sure this gets out here. This is important information. Nick, Lynn from Veterans Affairs, thank you so much. Amelie, Kim, Amy, thank you so much. We really appreciate your time. And Megan, my boss, she's online. Just wave real quick there, Megan. Thank you for allowing me to do this. She is my coordinator and pretty much makes sure that my mittens go through my jacket so that I can find out where I need to be. Thank you everyone for your time. Panelists, if you don't mind hanging on for 2 seconds, and then Megan, if you can close this out. Thank you and stay safe.